This video contains important information on preparing and serving a motion in family court. The most common reasons for filing a motion are to request a court order affecting child custody, parenting time, or child support. The court has forms and instructions for the most common problems. There are forms for the person bringing the motion and for the person responding to a motion. Please remember the court is a very formal place with a language and set of rules all its own. If you choose to bring your problem to court without an attorney, you must plan on spending many hours preparing your case and learning the court rules. You're expected to know and follow the law, just like an attorney. During this video, I will return to help you sort out the process. Let's get started.
The court has forms for the most common problems only. You must ask an attorney for help if you are not sure which forms to use, or the available forms do not fit your situation or address all of your concerns. A motion is a written request for a court order. A motion contains the names of the people involved, the date and time of the court hearing, the name of the judge assigned to the case, and a detailed explanation of what the moving party wants the judge to do. Sometimes an existing court order needs to be changed. Use a motion to ask the judge to issue a new order. Motions are also used to ask the court to enforce an existing order. Parties have access to a judge only if they follow the formal rules involved in bringing a motion. There are no shortcuts. If you have received motion papers from the other party, the court rules require you to prepare a responsive motion. The responsive motion tells the judge your side of the story. If you fail to file a responsive motion, you lose your right to tell your side of the story. Before you fill out motion papers, get a copy of the current order that you wish to change or enforce. The current order might be your divorce decree, a paternity order, or an order issued after a previous motion. If you do not have a copy at home, you can purchase a copy at the courthouse. Read the current order carefully to see if the judge has required you to take some action before filing a motion. For example, the order may require you and the other party to go to mediation before filing a motion for a parenting time problem. Sometimes orders require a parent to go to anger management classes or drug counseling before requesting changes in the parenting time schedule. Make sure you do everything required by your order before you file a motion. Next, if at all possible, take your order to an attorney. Explain your current situation and ask for help figuring out your options. Sometimes filing a motion is not your best option. The attorney can also assess how likely you are to get the order you want if you do file a motion. You can consult with an attorney without hiring the attorney to handle your entire case. If you cannot afford to pay an attorney to consult with you, ask your local bar association or the court administrator for information on free legal services. Caution: if your problem is an emergency and the situation places you or your children in danger, get legal help immediately. If you are going to file a motion or respond to a motion, and you are acting as your own attorney, obtain a packet of forms and instructions from court administration. To learn more about motions, we will follow John through the process of filing a motion. John and Mary divorced 4 years ago. In the divorce decree, the court awarded Mary custody of their 3 children. One of the children is a 15-year-old boy named Justin. Lately, Justin has expressed a desire to spend more time with his father. After giving it considerable thought, Mary and John have decided that it would be best for Justin to live most of the time with his father. John and Mary have put their agreement in writing. But to legally change custody, either John or Mary must bring a motion. John will file a motion to change custody. He selects a packet of forms available from the court for changing custody. John reads the instructions carefully before starting to fill out the forms. He learns from the instructions that he will fill out 2 forms, the notice of motion and motion, and the affidavit in support of motion. In these forms, John must explain what he wants the judge to do, change custody of Justin, and why he believes his request should be granted. Mother and father and son agree that Justin will be happier and do better in school if he lives with his father. After completing the 2 forms, John will get a court hearing date, make copies of the completed forms, arrange for someone else to serve copies of the papers on his ex-wife, obtain an affidavit of service from the person who served the papers, file the original papers with the court, and attend his court hearing. John thinks this looks like a lot of work. He's right. It is a lot of work, and the consequences of doing it wrong can be serious. If John fails to follow these steps, or omits necessary information from his forms, his case will be dismissed, and he may even be restricted from filing a new motion.
Sometimes people file motions for improper purposes. If a motion is filed to harass the other party, or if there's no legal basis for filing a motion, the judge will do more than just dismiss the case. The judge can order the person who filed the motion to pay a fine and attorney's fees to the other party.
In John's case, he has a legally good reason for bringing a motion, and he can go ahead with the forms. John will start with the form called Notice of Motion and Motion. For the heading of the motion, John will copy the heading from the divorce decree. His motion to change custody is a continuation of the divorce case. The parties, the case number, and the name of the court stay the same. Note that John was the respondent in the divorce. He is still the respondent on the motion, even though he is bringing this motion. Only the title of the document changes to state the purpose of the motion. The next section of the form is the notice of the court date, time, and place. John leaves this blank for now. He will obtain this information later from the court clerk. Next, John works on the section called Motion. John reads each item in the motion carefully and checks each statement that applies to his situation. John asks the court to change physical custody of Justin from Mary to John. He also asks the court to adjust child support payments.
Please remember that the forms provided by the court are designed to address the most common problems people have. Everything you want the judge to address must be included in your motion. If the form motion does not include something you need, you should add your request to the form. Use the catch-all paragraph on the form or attach another sheet of paper. However, if the form does not address all of your needs, that's a strong indication that you need legal advice from an attorney.
What will the attorney do for you? The attorney will help you answer the following important questions. Is the concern you have a legal issue that the court can do something about? It is possible that the court cannot fix the problem. You may need other services or strategies to address the problem. If the court can do something about the problem, what laws and rules apply to the problem? Your motion papers must meet the legal standards, or the issue you raise will not be addressed by the judge. The court's motion forms prompt you to provide the necessary information. But if you add an issue not covered by the forms, there is nothing to prompt you to provide the needed information. A lawyer can help you. John has now finished filling out the motion. He signs and dates the motion and writes his address and phone number at the end of the motion. By signing the motion, John acknowledges that he is not filing the motion for an improper reason and that he understands the court can order him to pay money to the other party if he does not have a valid reason for filing the motion. John also reads the notices explaining the other party's rights and responsibilities. He sees that Mary will have an opportunity to respond to his motion by filing a responsive motion. Next, John pulls out the second form, the affidavit in support of motion. John looks at the length of the affidavit in support of motion and starts losing his patience. Didn't he explain everything already in the motion? John checks his watch and realizes he must leave for work in 10 minutes. John should take a break and return to the form when he is rested and able to spend the necessary time. The form he has completed briefly states what he wants.
In the affidavit in support of motion, John must explain under oath why the requested order should be granted. To do that, he must state facts that support the legal standards for changing custody. The affidavit in support of motion is lengthy because the legal standard for changing custody is quite involved. The form prompts John to supply the information that the judge needs in order to change custody. John also needs to realize the importance of the affidavit in support of motion. When you're filling out your motion papers, think of the affidavit in support of motion as your testimony. With a motion, your testimony is written and given to the other party before the hearing. You may never have the opportunity to testify in the courtroom. All the information you think the judge needs to know should be included in your written affidavit in support of motion. If your written testimony is inadequate, the judge must dismiss your case.
John decides to put the affidavit aside and go to his job. He will finish the affidavit when he has more time. When John answers the questions on the affidavit in support of motion, he must write down facts that support his request, not his opinions. Let's go to a hearing involving a different family, the Bakers, to illustrate what it means to write down facts.
Ms. Baker, in your motion, you asked the court to order supervised parenting time. In other words, you do not want your son and his father to be together unless someone is there to supervise. Any decision I make about parenting time must recognize that the state of Minnesota wants both parents involved in a child's life. Under Minnesota law, I must first presume that both parents are fit to care for the child. Supervised parenting time restricts the parent-child relationship. I can order supervised parenting time only if the facts support a conclusion that it is dangerous or harmful to allow unsupervised contact between the father and the child. Ms. Baker, your affidavit in support of motion contains almost no facts. I quote from your affidavit, "I do not want my son to be alone with his father because last time they were together, my son said he doesn't want to go to his father's house again. My son is not safe at his father's house." Ms. Baker, your affidavit contains only one fact. My son says he doesn't want to go to his father's house again. This is not enough for me to conclude that your son is not safe in the care of his father.
But, Your Honor, I have a lot of other information I want to tell you.
I'm sorry, Ms. Baker, but you must write all the information in your affidavit so Mr. Baker knows the complaints against him and can prepare his written response before the hearing. Mr. Baker's attorney has asked that your request be denied because you failed to state facts to support your claim of endangerment of your child. Ms. Baker, you have not shown facts that your son is in danger when he is with his father. Therefore, your request for supervised parenting time is denied. Litigants tend to think they just need to raise an issue in their motion and then tell the judge the details in the courtroom. That's TV lawyering. In real life, the motion papers must contain all the facts important to the decision. If someone else has personally witnessed an event that supports your request, you may attach that witness's written statement to your motion papers. Keep in mind that the statement must be in affidavit form and signed by the witness in the presence of a notary public. Unfortunately, I can only guess at why the baker's son told his mother that he doesn't want to visit his father again. It could be something serious, but it could also be something trivial, such as he didn't like the dinner or his father wouldn't let him watch his favorite TV show. I cannot make a decision based upon a guess. If your child calls you at 11 p.m. and says he's alone, or if the child's school reports the child is always late when staying at the other parent's house, put these facts in your affidavit. Facts like these allow a judge to decide whether or not the child is safe and well cared for.
I guess Ms. Baker didn't understand the motion process. She should have spent more time on her affidavit in support of motion and learned what the court expected before filing her motion.
John is at the courthouse. He has finished his affidavit in support of motion, and he is signing the affidavit in the presence of the court clerk, who notarizes his signature after checking his photo ID. John has now completed the first of 7 steps. Next, John asks the clerk for a court date. The date, time, and place of the hearing and the name of the judge are filled in on the first page of the motion. John makes 3 copies of the motion and affidavit in support of motion, including all attachments and affidavits from other people, if any. John will keep 1 copy of all the papers for his records. He will send 1 copy directly to the judge. The 3rd copy must be served on the other party, his ex-wife. John keeps the original documents. At a later step, he will file the originals with the court clerk. John is now finished with steps 1 through 3. Steps 4 and 5 involve serving a copy of the motion papers on the other party and obtaining an affidavit of service to prove the papers were served.
Serving papers involves getting papers to the other party. Many self-represented litigants have difficulty with service, and it is important to read and follow the instruction in your court-approved forms packet. The service requirements vary depending on the type of motion, but these basic rules apply in all cases. You cannot serve the papers. Someone else must do it for you. The person who serves the papers must be at least 18 years old. Papers cannot be served on a Sunday or a legal holiday. Proof of service must be filed in the court file. The court staff will not serve motion papers for you.
Let's return to John. John's packet explains that in his case, the motion papers can be served personally or by mail. The instructions also explain deadlines for serving the papers and filing the originals with the court. John decides to use personal service. First, John gets his copies organized for service. Then John gives the copies to a friend who is at least 18 years old. John could also pay the sheriff or a private process server to serve the papers. The server must hand the copies to Mary. If the friend leaves the papers with someone other than Mary, service is no good and the judge will dismiss the case. Personal service means giving the papers to Mary personally. The papers can be served on Mary anywhere, at home, at work, or someplace else. Next, the friend fills out a form from the packet entitled Affidavit of Personal Service. In this form, the server writes his or her name and date of birth and states what papers were given to Mary and the date the papers were delivered. The server must sign the affidavit in front of a notary. John must get the signed affidavit from the server. He will file the original affidavit of service with the court at a later time. Personal service is not the only method of service. The instructions in John's packet say that he could serve the motion papers by mail instead of by personal service. If John were to serve the papers by mail, he would do the following. John would ask someone at least 18 years old to put the motion papers in an envelope addressed to Mary. John's return address must be on the envelope. After checking for adequate postage, the server mails the papers by first-class mail.
It's not necessary to use certified or registered mail. If the papers are mailed by regular first-class mail, there is a presumption that the other party received the letter. However, certified mail service might only be accepted by the judge if you have the return receipt card showing that someone at the address signed for the letter. Frequently, no one's home at the address, and the mail carrier leaves a card that the letter can be picked up at the post office. If the letter is not picked up by the service deadline, the judge might not allow your case to go forward. Now, back to the steps of serving by mail.
The server fills out the affidavit of service by mail and signs it in front of a notary. John gets the affidavit of service by mail from the server. Sometimes serving a party by mail or personal service is not possible because you cannot find the person. In that case, special procedures apply. Make sure you read all the instructions in your forms packet. Procedures will vary by type of motion. John is now ready to file the papers with the court. The papers must be filed a certain number of days before the court hearing date. Read the instructions in your forms packet to find out when the forms must be filed. John takes the original forms to the court administrator's office and gives them to the clerk for filing. He files notice of motion and motion, affidavit in support of motion and any attachments, and affidavit of service. It is possible that John will have to pay a court filing fee. If John did not pay a fee for the divorce, he will pay one now. John has prepared his papers, arranged for service on Mary, and filed all the original papers. The only step remaining is to go to the court hearing. John must attend the hearing at the scheduled time, or his case may be dismissed.
Hopefully, this video has helped you to understand the steps involved in starting a motion. The key points to remember are: read your existing order and do everything required of you by your existing order before filing a motion. Try to solve your problem outside of the court arena. If you must file a motion, read and follow the instructions and fully complete all forms. Please consult with an attorney if you have any questions or if the forms do not fit your situation. You can ask the court administrator for information about mediation and legal services. The role of the court is to provide you with a fair and impartial forum for resolution of legal issues. We want the court to be accessible to all people, but the amount of help the court can provide litigants is severely restricted by the need for the court to be impartial. The court staff will do what they can to assist you, but please respect their limitations. And remember, the forms and assistance provided by the court are not a substitute for sound legal advice from your attorney.